Welcome to another episode of this particular video. So today we'll be talking on the course Law of Contracts. This particular video is going to be for the general introduction into this particular course, while subsequently in our next videos we'll be speaking on auction, offer, acceptance. We'll be going deeper and deeper in a step-by-step approach into this particular course. So today is going to be for the introduction only, and the definition, meaning, and what we understand by contracts. That's going to be for this particular video. So I know you guys must have heard of the phrase almighty law of contracts. You see, when I got into my 200 level, that was the kind of word I also heard also. They would say almighty law of contract, almighty law of contract, and people were panicking. But that kind of word was one of the things that made me to study more for this particular course. So you guys should not be scared of this particular course. Just follow it in a step-by-step manner. Not that you don't understand the types of contracts, then you just jump from there to acceptance, jumping one subtopic to another. So just follow it in a step-by-step manner. So now we are going to be looking at the definition of law of contract, what we understand by contracts instead. So let's take an example. S, let's use this particular example. S gets into a contract with Y, and S tells Y, okay, Y, supply me 3 bags of cement and I will pay you 10,000 naira. They came together, they met together, they reasoned together, and they signed the document. Or it might have even been an oral contract, and that is just contract for you. Both two parties come together and form a contract. They say, do this particular thing for me. In exchange, I will do this particular thing for you. That's contract. So today, let's look at the definition of contract. I prefer the definition given by Galadima in the case of Tabo Air versus Taffa. Cabo Air versus Taffa. In this particular case, Galadima JCA, as he then was, held that a contract must be an agreement that is legally binding on the parties to it. A contract must be an agreement that is legally binding on the parties to it, and which, if broken, may be enforced by an action in court. A contract must be an agreement. S meets Y. Do this, supply me 10 bags of cement. I'll pay you 10,000 naira. They agree, okay, I will supply you. It must be an agreement which is legally binding. You see, a contract should be legal. For example, a contract whereby someone tells another person, write exam for me, write this particular course for me. That's an example. Help me to write this particular exam. I'll pay you 10,000 naira. It's not legal. So a contract must be an agreement that is legally binding. It must be legal. A contract must be an agreement that is legally binding on the parties to it, and which, if broken, may be enforced by an action in court. So if S or Y later, after agreeing to the contract, after agreeing to supply this 10 bags of cement, 3 bags of cement for 10,000 naira, and subsequently refuse to, and it cause injury to Y can sue S for breach of contract. That's what this course, that's what contract general is talking about. That is why Galadima JCA held that a contract must be an agreement that is legally binding on the parties to it, and which, if broken, may be enforced by an action in court. That is contract for you. There's no the almighty there. So I've heard this sentence, for every contract there is an agreement, but not every agreement is a contract. For every contract there is an agreement, but not every agreement is a contract. For every contract there is an agreement. But not every agreement is a contract. What does this mean? It means that for every contract, there must be an agreement. For every contract, there must be an agreement. The parties must have agreed to be bound by that contract. The parties must have agreed together. The parties must have agreed together to be bound. The parties must have agreed together to form a contract. That's what it means. It means the parties together, the parties must have agreed to form a contract. So for every contract, there must be an agreement. But not every agreement is a contract. Not every agreement is a contract. For every contract, there must be agreements. Both parties, both X and Y, must have agreed together. But however, not every agreement is a contract. This means that it is only those agreements that satisfy the essential ingredients of a contract that is valid. For example, a brother enters a brother, let me say A, B. Both of them are siblings. A tells B, that's his sister, okay, help me to fetch water from the tank. I'll give you 5,000 naira. 5,000 naira. Then B, because of that, took the bucket, fetch water for A. And after fetching the water, A refused to pay her the 5,000 naira. Can B then institute an action against A? The answer is no. Why? Because one of the ingredients of a contract, which is intention to enter legal relation, was not present. So a contract, though there was an agreement, but there was no contract. There was an agreement between the brother and the sister, but there was no contract because one of the ingredients was not present in this particular contract, in this particular case, in this particular agreement. One of the ingredients was not present. That's why the phrase, for every contract there is an agreement, and not every agreement is a contract. That's just it. Thank you so much for watching. God bless you. Have a nice day.